This is Climate One. I'm Greg Dalton. Western law generally treats the natural environment as property, with all rights resting with its owners.
So if we're treating the earth and if we're treating ecosystems as property, then ultimately we as property owners have the right to destroy our property. And that fundamentally has to change.
If corporations can be legal persons, why can't Mother Earth? And who should defend the rights of our collective natural resources?
What are the rights and responsibilities of individual owners versus the government's obligation to preserve those resources, or at least some decent quality of the resource, because we all rely on that. We can't live without water or air.
Can a forest or river have legal rights of its own? Climate One's empowering conversations explore all aspects of the climate emergency. I'm Greg Dalton. In the last several years, a growing number of countries and places within the U.S. have tried to establish legal standing for natural ecosystems. In 2017, New Zealand granted the Whanganui River the full legal rights of a person. India also recently granted full legal rights to the Ganges and Yamuna rivers and recognized that the Himalayan Glaciers have a right to exist. In the United States, those efforts have been more complicated and frequently overturned by the courts. I've invited two guests to talk through the history and complexities of the rights of nature. Lindsey Schromen-Wawrin is an attorney at Shearwater Law in Port Angeles, Washington. He's worked since 2013 for the Community Environmental Legal Defense Fund, where his clients have included the Lake Erie ecosystem and the Crystal Springs ecosystem. Rebecca Tsosie is a Regents Professor at the University of Arizona College of Law. Tsosie is of Yaqui descent and a faculty co-chair of the university's Indigenous Peoples Law and Policy program. I asked Rebecca Tsosie how her thinking about the rights of nature has evolved over time. She says it wasn't something she thought much about until she started studying law.
Law school was actually a happy accident for me. There wasn't anybody in my family that had ever gone to university or law school. And when I got into my field, which is federal Indian law and the rights of Indigenous peoples, I was so taken with the rights discourse and this idea of human rights and civil rights. That became one of the cornerstones for my scholarship. So I have since learned to appreciate the discourse of rights in general, and the rights of nature, of course, is a part of that discourse. But I think it's a stretch for the American imagination to go into the rights of nature, because we usually associate them with persons.
Right. We'll get into kind of the common roots. The very existence of a human, initiates some rights, and the very existence of nature kind of spawns some rights, so to speak. So, but how do you explain the rights of nature as a concept?
So the concept really posits that the way that we envision a person having particular rights and standing to sue in case somebody harms you, that can be extended beyond human persons to aspects of what we would describe as the natural world, an ecosystem, a river, a mountaintop, a national park, whatever the case may be. So it is to have an entity withstanding to sue. Now, it's not such a stretch, because we actually do obviously think of corporations as legal persons, and we think of, a ship can be a legal person. So we do have these categories in the law of inanimate objects that can have personhood in the legal sense.
Well, isn't the right of a corporation as personhood relatively new? I always remember Stephen Colbert saying that I'll believe a corporation is a person when Texas executes one, right? Isn't that relatively new?
No, actually, the legal status is the collective acting as an individual. So the way that corporations are set up is as an individual legal entity with status. And obviously the individual shareholders are part of that. So we have a group that is represented by that legal identity. Now, I think the novel twist in the modern era has been to think of what we term the rights that are, core to individuals: freedom of speech, freedom of religion. And all of a sudden you extend those rights to corporations. Well, that's different than the types of legal status rights that go with a property or contract transaction. So it is that part that is newer in the jurisprudence.
Right. From recently, Citizens United or whatever. Yes. Lindsey, how did you come to be interested in the rights of nature?
As an undergraduate student, I was an environmental studies major, and that often focuses on environment, economy, and society. And we didn't really get into the structure of the law and how it shapes the way that we think about the natural world or about ecosystems or the planet in general. In my 20s, I taught field science education, and we would teach students definition of ecosystems about it's all the parts of the living and non-living world. Sometimes I'd have a student, always an indigenous student, who would say, "What do you mean non-living parts of the natural world?" And I'd be like, "I know what you mean. Just if you're asked this on, the Washington State standardized tests, just put that down, but you don't have to believe it, And I found myself wanting to do more structural social change work. So I ended up going to law school because I was like, well, if I want to change the system, I better know what the system is, and found that I was going to go to Spokane, where the Community Environmental Legal Defense Fund had been doing some work in the previous year or so. So I signed up for the democracy school. I was exposed to this idea of rights of nature and, kind of the structure of law that gives corporations more power than people, and our ability to protect our communities as well. And I was very skeptical. I mean, I was a science educator, right? So skepticism. And I'm like, this can't be how we've structured our legal system. And so I'm then in my first week of law school, and I'm looking for some of this stuff, right? Because where is it? And I mean, no spoiler alerts, but like, you don't cover this stuff in law school. The whole first year of law school is really about reasonableness. It's not about justice. And so my first summer of law school, I worked on a signature gathering campaign to put an initiative onto the Spokane city charter, like the constitution for the city. And it included rights of nature for the Spokane River. And basically saying that the Spokane River and the associated aquifer had the right to exist, flourish, and naturally evolve. And at one point, I'm outside a grocery store, and I'm standing there collecting signatures. And I think for context, I'm a white guy with white skin privilege, and this woman who appeared to be indigenous is walking into the store. And I say, "Hey, would you like to sign an initiative to give rights to give the Spokane River the right to exist?" And she stops and she looks at me and she says, "You're finally figuring that out."
Yeah. Yeah. Finally figuring that out. Boy, so how did you feel in that moment? Did you just kind of feel shamed or chagrined, or how did?
Well, she signed it. No, I mean, yeah, it's this thing. We're finally figuring this out. In Western legal systems, Western thought is really slow to this. And so we have to unpack hundreds of years of the way that we think about our relationship to the earth in order to get to this paradigm shift that rights of nature represents. Another time that summer, I was gathering signatures at a festival, and this guy comes up and really wants to read the text of the entire thing. So I let him read it. And then he comes back and he points at the rights of river provision, and he says, "This goes against 500 years of Western property law." And I pause and I think, is it only 500 years or is it further? But I just say yes. And he's like, "I'm glad, because that is what we have to do." And he then shares that he's a lawyer, and he remembers that first day of property law class when the professor explains what property is. And it includes things like the right to use your property, the right to transact your property, the right to exclude others from using your property. And ultimately, it includes the right to destroy your property. So if we're treating the earth and if we're treating ecosystems as property, then ultimately we as property owners have the right to destroy our property. And that fundamentally has to change.
Rebecca, what did you learn about property law in law school and coming in with your perspective?
So I think Lindsey's absolutely right that is how the American legal system works. We inherited it from Great Britain. and Blackstone's version of property was one of absolute despotic ownership. The owner could do anything. And so we imported that into the United States. But the interesting thing is, in the context of this conversation, to imagine what the rights are to what we are framing in U.S. law and international law as resources, water resources, air resources, wetlands resources, species, animals, plants, resources. What are the rights and responsibilities of individual owners versus the government's obligation to preserve those resources, or at least some decent quality of the resource, because we all rely on that. We can't live without water or air. So what is the government's obligation, and how do we frame that as against this absolute notion of property rights? So we have mass movements now around public lands, for example, on both sides of that equation, that the government ought to protect these lands for the collective benefit. The controversy over Bears Ears National Monument, for example, local, people there said, well, hey, we want to be able to develop that. We want to be able to engage in fracking, and we can lease these lands and we can make money off of them, and the whole commodification thing, versus the value of that place is immeasurable as it sits there as the site of all of those affiliated indigenous nations that have always been part of that place. And that was the beauty of the proclamation that President Obama established, because he said, these are current living nations. They've always been here. The knowledge about that place is invaluable, and they will have a seat at the table with the federal agencies in a co-management regime of something that is precious as a national resource. And I think that you saw that, for example, in the climate litigation, the Juliana case, that idea that there's an atmospheric trust, that one generation doesn't have the right to take away the right of the future generations to survive. And that is a pivotal concept that within many indigenous traditions, and I know Oren Lyons of the Haudenosaunee has spoken about this, the seventh generation, that is the frame of your thinking as a current people. You think for the seventh generation, and you plan, and you protect, and you preserve, and you act in ways that are in that way sustainable.
And that's very different than capitalism that's driven by quarterly profits and quarterly earnings and very short-term outlook. I've learned a lot as Lindsey said earlier about, the white privilege he walks around with. I've learned a lot about mine and the holes in my education. And one of those is, not really, so I sort of knew that indigenous nations were sovereign nations, in the United States. But I honestly thought of indigenous people as people of color and was schooled on that by some indigenous leaders, like, no, that's hence BIPOC, right? And I think a lot of Americans don't realize that tribes are sovereign nations. So how does tribal law and U.S. law interact when it comes to the rights of nature cases?
So that is my specialty, federal Indian law, and we have 574 federally recognized indigenous nations within this country. And we also have many indigenous peoples that lack that level of federal recognition. For example, Native Hawaiian people are definitely indigenous. They were part of the Kingdom of Hawaii before it was unjustly taken, but they don't have that status. And similarly, there are other nations, for example, Louisiana, encountering climate change there on their ancestral homelands, but they lack the political status to actually have standing in terms of their land rights. So you're right, the sovereignty of American Indian and Alaska Native nations is a territorial sovereignty. It stems from their status since time immemorial as separate nations. They engaged in treaties with Great Britain, also with the United States. You have to have a separate political status to engage in a treaty relationship. And it is that has become domesticated as this domestic dependent nation status. But reservation lands are not part of the states where they are. They are separate jurisdictional enclaves. Tribal governments exercise judicial, legislative, executive powers on their lands and over their members. And that is the relationship that sustains them in these claims to ancestral homelands that are now on different lands, right? So they have jurisdiction over their reservation lands as governments. No question about that. They have property ownership as well. But what if you're on public lands that were the ancestral lands and still have those sites of great historical and cultural significance? So there are a panoply of rights that go with that political status. For other Indigenous peoples, as well as the federally recognized tribes, the language of human rights ensures that there is a consistency for national governments to recognize the unique status of Indigenous peoples, whether or not the government has crafted a special political status for them. They have human rights to land, ancestral territories, and the articles in the Declaration also talk about spiritual rights. It is the only place in human rights law that talks about spiritual rights. That is not the same as religious rights. Spiritual rights are a different metaphysics that attaches land and people through time, ancestors, and future generations. So that metaphysics is built into Indigenous human rights, and that is what we are protecting in some sense with this conversation about the rights of nature, knowing that Indigenous peoples are the traditional custodians, stewards of the lands that they have been on since time immemorial.
You're listening to a Climate One conversation about the rights of nature with lawyers Rebecca Tsosie and Lindsey Schromen-Wawrin. Coming up, we dig into the nuances of this legal framework and talk about some of the places where these arguments have been put into action.
A legal person usually has the right to sue and be sued, to own property, and to contract with others. Should ecosystems have that same set of personhood rights, or should it be different?
That's up next when Climate One continues. This is Climate One. I'm Greg Dalton. We're talking about the rights of nature. I asked Lindsey Schromen-Wawrin to respond to the argument that nature already has rights, as exemplified by energy companies frustrated by a threatened desert tortoise that holds up construction of solar farms.
Our legal system really treats everyone and everything as either person or property. And so what the government is doing with those regulatory environmental laws is trying to regulate the use of property. Just because somebody has property doesn't mean they can use it in every way they want. So kind of the bargain that was made with setting up the current environmental law system was to make environmental law a subset of property law and say, okay, you can use your property up to this point. You can use it only this much. There are going to be limits to pollution. There are going to be limits to destroying all the habitat for the desert tortoise. And what we're thinking about with rights of nature is actually moving how we treat the earth from the property law sphere to the constitutional law sphere, where we're talking more about this is a thing or a legal person that has rights. So in constitutional law, we're often talking about structures of government and power, but we're also talking about who has rights and thus duties. And so it's categorically changing the nature of ecosystems within the law from being something that's legal property to a legal person. And everything else kind of flows from there. The analogy in our history, and I think this is a sensitive analogy to make, so I'm just making it in the legal context, is emancipation of slavery, the end of slavery, in that human beings who were considered under the law to be property are now legal persons. That's an example of a major shift in how the law viewed an entire group of people, taking them from being property to being person. Essentially, the concept of rights of nature is talking about a similar transformation conceptually with ecosystems.
Right. So that's happening all over the world. Rebecca, this concept, which you noted started about 50 years ago with this law professor from USC, who, at least in the United States, it is spreading around the world. Give us a sense of the scope of where this is gaining traction internationally. How many jurisdictions, how many countries? Because this really is an international movement from New Zealand to Bolivia to where else?
So it is definitely gaining traction. And I think part of the strand came from the conversation at the Rio Declaration and beyond about the earth, right? The rights of the earth, Mother Earth. And there was an indigenous participation in that with the Bali Declaration. So a lot of the countries in Latin America did formulate that as a constitutional provision that the earth has rights. Now, it sounds good in the abstract, but there are still resources embedded within there. There are, oil and gas deposits, and there are indigenous peoples that live on those lands. Even if you recognize that the earth has rights, humans will still use the earth for their purposes, and those, considerations that we just spoke of in terms of indigenous human rights are still very, very much implicated in many of those countries. New Zealand, I think, set a great standard. The Maori people have a treaty. They are tribal nations, but they have one treaty, the Treaty of Waitangi, and that treaty process is still ongoing. And they actually have been successful in getting the New Zealand Parliament to legally grant personhood to now 3 natural features. The river was the first. And there's a Maori term for that, which I won't try to read, but the river is a legal person and has all the rights, powers, duties, and liabilities of a legal person. Now, if you listen to that, yes, it has powers and duties. It also has obligations, liabilities. And my understanding was that India, when it termed that Ganges River was also a person, but then it overflowed and flooded and had lots of liabilities. And so anytime you're talking about legal personhood, there's a kind of a pro and a con to that, because you sue and you can be sued. So who is the guardian in a human sense of these entities is the interesting question.
Lindsey?
Oh, there's so much to unpack here. It's so exciting. And this is where we're at right now with this idea is I think in the last couple of years, we've moved beyond this, what I'll call an initial phase of rights of nature, which is, in Christopher Stone's words, the unthinkable. What do you mean? Like that ecosystems could have rights? That's just impossible. We can't think of that. To now actually being in the phase where we're talking about the details of it, like how would this actually work? What are the legal mechanisms by which this works? And we have a number of examples worldwide to look at. In this second phase, I think there's some really important things for us to consider, and how we approach the particular mechanisms for rights of nature is going to determine whether it actually works as a paradigm shift or simply recuperates a system that is ultimately destroying the earth on which we depend. And my hope is that we create a paradigm shift and get the world we want. In this second phase, one of the issues to consider is this question of liability. When we deconstruct what a person is in the law, even before we get to constitutional rights, there's some basic things. It's a legal person usually has the right to sue and be sued, to own property, and to contract with others. Should ecosystems have that same set of personhood rights, or should it be different? And I think that we should be very careful about the idea of ecosystems being able to be sued or being able to have liability. And that's one of the things that could derail, in my opinion, the ability for rights of nature to be a check on destructive activities, and instead could set up, kind of like natural resource trustees for ecosystems where there's a flood and now the ecosystem has to pay out of the fund that would otherwise have gone to restoring habitat that had been destroyed.
But Lindsey, if I could jump in there, that sounds like there's that position means that ecosystems have the benefits of personhood, but not the liabilities or not the responsibilities. They want the good without the other side of the ledger, right? And that sounds like imbalanced, right?
Well, the imbalance is in our system now, where we are doing a one-way path of taking ecosystems and turning them into money, and we have no way to go back. But yeah, I mean, children are kind of similar. There's this whole fun conversation you have in contracts class about, can children contract? Do they have the capacity to contract?
They have protections without certain responsibilities. I want to move to, in 2019, the Lake Erie Bill of Rights was passed in the city of Toledo with 61% of the vote. But then a year later, a single federal judge struck it down. Lindsey, you were one of the lawyers involved in that. Was that a win or a loss? What does that mean? And that was pretty significant, I think. Were people in Ohio voting to give lake rights.
Yeah, so I think the Lake Erie Bill of Rights, at least in the U.S. context, was one of those watershed moments, no pun intended, for this concept of rights of nature in the popular understanding. So as far as the court case went, the people of Toledo voted to add rights protections to Lake Erie and its watersheds. The significant one for Toledo is the Whanganui River, which is the largest river to flow into Lake Erie, and it brings a lot of contamination from factory farms upstream, and that's what's causing the harmful algal blooms in Lake Erie that shut down the Toledo water system for 3 days several years ago. Basically, the Farm Bureau sued the city of Toledo, and the court said Toledo doesn't have the authority to pass this law, and therefore avoided the law. So on a legal technical aspect, the law is no longer in effect. I would say on the larger cultural transition that we're making, this idea of needing a paradigm shift in the law, I think the campaign and what people did in Lake Erie was highly successful. We might not be having this conversation now if they had not said, we can't live with the system as it is, and we need a different system that recognizes our ability.
I'm talking with lawyers Lindsey Schromen-Wawrin and Rebecca Tsosie about the rights of nature. We'll continue our conversation later in the show, but first we'll hear a personal story of someone who used the rights of nature to defend her home ecosystem. Carol Van Strum and her family moved to the coast of Oregon in the 1970s. She didn't know then that she would end up leading a fight to protect those lands from clear-cutting and herbicide spraying. Van Strum says it all started in the spring of 1975.
My kids were down by the river, which runs, it's through our property, but it's on the edge of it, and the road runs along the river. And they were down there fishing and playing, and a spray truck came along, and I don't think the guys on it saw the kids. They just were busy with their high-pressure hoses, spraying everything in sight, including the river itself. And my kids got very, very sick that night. And when we called to find out what they were spraying, we were told it was perfectly safe, 2,4-D and 2,4,5-T. They're safe as table salt. And I said, well, could they have put the wrong thing in the truck? Maybe they made a mistake. And no, they knew it was the right thing. And within a few weeks after that, helicopters were spraying the ridges around our place, which of course drifted immediately down onto our place, which is lower down, and killed half the things in our garden. But also a few weeks after that, our poultry, the ducks and geese and chickens that were in eggs, they hatched. And a lot of them, more than half of them, were deformed. They had wings on backwards, feet on backwards. Some had no wings, and they had crossed beaks. And so we started researching what they were spraying and found out it was the same as what had been in Agent Orange that was used in Vietnam until a few years before that. And wrote a letter to the editor of our paper and found out when we got flooded by neighbors other people in the area who'd had similar experiences, and nobody connected it necessarily with the spraying itself because they didn't know what was being sprayed. So that was the beginning. We ended up with our neighbors suing the federal government and stopping the Forest Service from using one of the main ingredients in Agent Orange, 2,4,5-T, and in subsequent lawsuits stopped them from using any herbicides aerially in our forest. And finally, that expanded to the national forests in the whole nation.
Wow, I just want to ask, how old were your kids and how sick did they get?
Well, it ranged from, I think, age 7 to 13. And yeah, they got really sick, vomiting, bloody diarrhea. They had headaches. It was pretty dramatic. And when we went down to the river the next day, everything was dead. There were dead fish, dead merganser ducklings, and crawdads floating, just washed up along the edge of the river. There was very clear that something awful came through our place.
Well, that's quite a sad story to have Agent Orange sprayed on your kids and then to win a lawsuit that has national implications. What we're talking in this episode is about the rights of nature. What does the rights of nature mean to you, having won this big battle such as you have?
Well, it's more than just the spraying of poisons on our forests. It's the only reason they really need to do that is because of clear cutting. And that's one of the most devastating things you can do to a forest. They clear cut it. It's basically strip mining. Everything is cut down to bare dirt. And then they want to plant a plantation of only commercially valuable Douglas fir. And then they continually spray off and on for the first 5-6 years to kill off anything that sprouts, because nature replenishes itself. There's bare dirt and sunshine, it's going to grow things. And the timber industry considers those all to be weeds and sprays them with things that supposedly kill everything except the Douglas fir.
So is this battle really over? Even though you seem to have won in court, but is the battle really over?
No, it's not over, because the only thing we won applied to federal lands, which in my county, my portion of the county is mostly Siuslaw National Forest. But in other parts of the county and Oregon and the Northwest, there's mostly timberland owned by multinational timber companies, and none of those the things we won in court applied to them. Only state regulations apply. So that was 40 years ago that we won those injunctions against the federal government. But the state government, which I'm sorry to say is controlled largely by corporate money, has very favorable laws in place on pesticides, so that the timber companies routinely spray and clear cut vast areas of the forest. And what they're replacing is real forest. It's many species of trees and fungi and lichens and mosses and all the wildlife and other things that make up a real forest, and they're replacing it with plantations that might as well be corn because they're just one species. That's what we're fighting ultimately, is the practice of clear cutting.
And in your legal cases that have banned the use of these chemicals on federal lands, have you used a rights of nature legal framework to ban aerial spraying?
No, not on federal lands. The only law we really could apply was NEPA, the National Environmental Policy Act. All that requires is that the government prepare environmental impact statements telling the effects of what they're going to do, and they can go ahead and do it. But they hadn't done that in our cases originally. And then ultimately, in subsequent lawsuits. We were able to show, that the result of the research I did for my book, A Bitter Fog, was being able to show that all of the pesticides being used in the national forest, in fact, probably in the nation, were registered on the basis of non-existent or fraudulent data, safety data. And the court ruled, and the Ninth Circuit agreed, that the Forest Service can't use those chemicals relying on EPA registrations, which in turn rely on that false information. They would have to do their own research. And of course, the Forest Service couldn't do that. And that's why they ended up changing their policy on clear cutting so that they wouldn't have to use these poisons.
But it's still allowed on private and corporate lands.
That's right. And that's where the rights of nature came in, was our county and this is 40 years after our battle with the feds, okay? A group formed in Lincoln County called Lincoln County Community Rights. And their goal was to stop the aerial spraying of pesticides on corporate timberlands. And they introduced a county measure that would ban it. And included in that measure was a rights of nature that gave anybody could speak in the courts in defense of natural systems. The voters in the county passed the measure. Immediately, the timber industry challenged it in court. And it was at that point that the community rights folks asked me if I would speak for the river system here in defense of that provision in the measure. And that's how I became the Lorax, speaking for the trees. I've never been so honored. I mean, to me, that was amazing that they chose me to do that. They actually found a Lorax costume. And at any kind of event in the county, like they have parades on, Memorial Day or whatever, and they would parade as a group with the Lorax, educating people about protecting our ecosystems from these poisons. So it was a wonderful thing.
Such a powerful story. I read the Lorax was Dr. Seuss's favorite book, or one of his favorite books. It's so powerful. What does aerial spraying of forests have to do with climate change?
Well, again, it goes back to clear cutting, because the connection is kind of vivid. Because when you old growth forests, real forests, multi-species, like I said, store and sequester massive amounts of carbon, and they're cutting them all down and replacing them with these plantations that are all one species. They don't only grow them for 30 or 40 years and then mow them down to make paper or whatever they do with them. So they're not storing, they store far, far less carbon. And the huge amounts of energy required to do all that, not just talk about logging equipment. Go take a look at some of it. It's massive, and it uses huge amounts of fuel. It pumps out massive amounts of exhaust. It's amazing what it takes to destroy a forest.
Timber companies have sued the county to try to nullify the ban that you helped get passed. On what grounds, and what's the status of the case?
They sued in 2017, soon after the measure passed. And the judge sat on it for 2.5 years. So for those 2.5 years, nature had rights in our county, which I'm proud of. But then finally she issued her ruling this past year and ruled that the state law allowing the poisoning of the forest it preempted any county control. So that's where things are at the moment. We're appealing the judge's decision. It was interesting, though, in the original hearing with that judge, she did not allow the river system, via me and the Lorax, to intervene in against the timber companies, but she did give a little speech saying she thought even though nature didn't have rights now, it should and will.
Carol Van Strum is author of A Bitter Fog and a farmer, parent, and self-described troublemaker in Lincoln County, Oregon. She's featured in an upcoming PBS documentary called The People vs. Agent Orange. You're listening to a conversation about establishing rights for the natural world, like a river, mountain, or ecosystem. Coming up, what does it mean to decolonize our thinking about the law?
It is time for another paradigm shift because there is now an imperative with what is happening to our climate and our natural world, and it is our obligation to see that. To decolonize your thinking means to situate yourself in an interdependent universe.
That's up next when Climate One continues. This is Climate One. I'm Greg Dalton. We're talking with lawyers Rebecca Tsosie and Lindsey Schromen-Wawrin about the legal rights of nature. In 2019, the city of Pittsburgh, Pennsylvania passed an anti-fracking law that included the phrase, quote, natural communities and ecosystems possess unalienable and fundamental rights to exist and flourish. It also said residents shall possess legal standing to enforce those rights. I asked Rebecca Tsosie about the significance of that law.
I think it is very significant, and it's an area that is highly contested right now. So the human rights sort of movement really encompasses the needs of local communities to a great extent, right? Because the community is vulnerable in ways that maybe the national government doesn't see when it enacts the Clean Air Act or the Clean Water Act. And then somebody has to enforce that. But we got the Flint, Michigan case, right? Somebody wasn't enforcing what they should have been enforcing. So local communities suffer from that. They get the lead right in their water, or they get the pollutant. And fracking is very, very damaging to many communities on several levels, human health and property damage. So the idea that the community should have a right to protect itself against these harms that is separate and independent from the pollution control ordinances is very important. But there's also a strand, Lindsey talked about the constitutional doctrines. So there are constitutional doctrines both of standing, how you get into federal court to vindicate your federal rights, or how you get into state court to vindicate your state rights. But there are also issues where you're having a human rights violation occur, and those regimes do not recognize your standing to bring your claim. What do you do then? And so local control is very important. But if the state really wants fracking in the state can do that and preempt local governments. Similarly, the federal government can preempt state governments. So those are the areas of constitutional law that still have to be adjudicated within the powers jurisprudence.
Lindsey, in the corporate sustainability world, there's a big effort called ecosystem services to basically put a monetary value on the services that nature provides to people. A forest cleans water that trickles down into a stream that benefits humans, or perhaps a factory. And the idea is that if we, for corporate, and this is a very corporate-centric view, that if something has an economic value on it, it can be measured, it can be protected. A tree standing doesn't show up in the GDP, but a tree cut down and made into furniture or paper, shows up in GDP. So if we assign an economic value to a tree providing shade and other ecosystem benefits, that's a good thing. Do you see that as a good thing, supporting the rights of nature, or more exploitation and extraction?
That is one of the questions that I'm trying to figure out, because I totally see how, as you just described, if we don't give value to something and measure that value, our current system doesn't consider it to have any worth. And yet at the same time, that valuing is a form of commodification and estrangement and alienation from things that are sacred or have value beyond their economic meaning. And potentially the answer is we'll change the system. But exactly how do we do that? To make a historical analogy, a Emancipation Proclamation and the 13th Amendment that ended slavery except as punishment for a crime didn't create justice for formerly enslaved people. We are still wrestling with that today. 150 plus years later. And so if we only say rights of nature and don't look at the economic implications, the monetary design and monetary policy implications of our treatment of ecosystems, I don't think we're going to go all the way. And we have to see the political, the rights-based conversation as tied together with economic.
Rebecca, if we give more rights to nature, are the rights of people reduced or demoted?
I would like to say that everybody will benefit if we have a system of value that is inclusive of human persons and other than human persons to use this frame. If we look at many indigenous languages, rocks, mountains, streams, they are entities that have value, and they are specific values. It's not that they're fungible. They each have their personality. They do what they do. Your job as a human being is to work with them in their essence, and that's what ensures sustainability over time. And those are the lessons embedded within what we now call traditional ecological knowledge, for example. But it's really a scientific system that says this is the way that the river operates. This is what happens when we have these cycles of drought. This is what people need to do to interact with that successfully and survive. So those lessons are embedded in it. The frame of rights tends to be oppositional. I have a right. I sue you. You have to pay me. You don't like me. You feel like you got the short end of the stick. That is the frame of rights discourse. If we go into indigenous epistemologies, many times it's a relational universe that comes with mutual responsibility. So you do have a responsibility to other people, to the natural environment. When you transgress that, you are going to suffer, but you cause your own suffering. I believe that is probably what is happening right now, but we are not accustomed to thinking that we are causing our own suffering. So, for example, we buy bigger vehicles thinking, well, China is engaging in fossil fuel development. So if I buy a big vehicle, it's not my fault. They're really the wrongdoer. And so, but we are contributing to our condition. We just are not taking responsibility for it. So I think the frame of value and responsibility gets toward mutuality and reciprocal obligations. In a sense, everybody benefits from that.
Yeah, I think the key word there is the relationship. Our relationship is broken, or we don't think about it as a relationship. We think about rights. Rebecca, we've heard a lot recently about how the colonial mindset still pervades the way America was set up and how lands were stolen and still pervades kind of the patriarchy that we have today. What does it mean to decolonize the law?
That is a great question, Greg, and I think that people don't agree on what it means to decolonize the law. But one of the things for Indigenous peoples would be to say the original law is still here. The people are still here on the land. The land is the law in many ways in this frame because it designates the responsibilities that we have to care for it and that it has to us as long as we do those things. To decolonize thinking is what we have to do. We still have our system of property law. Are we going to get rid of our system of property law? I don't think so. Are we going to get rid of our U.S. Constitution? I don't think so. So there will somehow always be a colonial element to our legal system. I think it would be very hard to decolonize the law, but we can decolonize our thinking. And that is what I think Lindsey is positing with this idea of a paradigm shift. We have had paradigm shifts in the history of this country, and this country is very young. compared to many world civilizations of countries. We're a baby country, and we've already had those days of reckoning where we had a paradigm shift. It is time for another paradigm shift because there is now an imperative with what is happening to our climate and our natural world. And it is our obligation to see that. To decolonize your thinking means to situate yourself in an interdependent universe, to recognize that we all rely on the forest. The global forest is a hugely important asset to global survival. And it doesn't matter that we're in this country and Brazil is over there with the Amazon. That is our forest, and that is what keeps us alive. And similarly, the waters, they're like the veins, right? They carry the lifeblood and that delicate cycle. We have to recognize our obligation to come together and regulate that in ways that are sustainable. That is what it would mean to decolonize the thinking about the planet that would afford a right to all of these ecosystems to flourish and to sustain us into the future.
Lindsey, to wrap this up, if you think about people on the political right who have been very astute and savvy about getting legal cases that they are aiming at the Supreme Court, whether it's something change that they want to enact, whether it's on gun legislation, reproductive rights, whatever, that they're very savvy about aiming toward the Supreme Court. As you think about the rights of nature, if you could craft a path for one of these laws, whether it's Ohio, Pittsburgh, somewhere else, to go up to the Supreme Court, is that possible? Is that part of the strategy? What would that look like?
We're giving judges right now the opportunity to look at these ideas and say, you know what, we want to change our thinking on this, whether it's about state interference with local democracy or rights of nature or corporate rights. I'd like to air quote rights. But so far they're not biting, and so that probably means that there's a couple things going on. One, we don't have the political power. This is not about lawyers. This is about mass social movements emerging from the grassroots saying we need to change our system because it's leading us over a cliff that we cannot go off. And without that, it doesn't matter how silver-tongued the lawyers are before the U.S. Supreme Court. The court responds to popular opinion, and we need this larger movement that says we can't continue to treat the earth as property, and we must recognize that the earth and its ecosystems have rights. And that's ultimately going to lead to a change in the legal system. There's going to be some mechanisms. Does this happen by state constitutional amendments, and then those are affirmed as valid by the courts? But really what's going to make or break this is all of us working together to say that we have to make this change.
Rebecca, a lot of the lands around the world that are going to really determine whether we stabilize and heal the climate are in indigenous hands or should be. So as you think about expanding indigenous rights, what is your wish for that playing out? Clearly, a lot of this is bigger and will be longer than the Biden administration, but we do have a window now where a U.S. administration is centering on inclusion and justice. What's your hope for the future?
The recent UN assessment that was done that showed that most of the world's biodiversity is located on the lands that are inhabited largely by indigenous and local communities. That was the proof that many of those ancestral ways of dealing with climate, with land, with water in a sustainable way, they work. And so when you saw the forest fires, for example, in Australia, the lands that were stewarded by indigenous peoples survived that, and the other lands, did not. So these are the lessons that we have. Now, how do we take that to a level of governance? I am very interested in, and I think that part of the paradigm shift is going to be to look at the human rights frame of self-determination is inclusive of environmental self-determination, right? It is the survival on those lands that ensures the integrity of the land, but the people's attachment to it, the stewardship of that is pivotal. So how do we ensure that Indigenous peoples are able to continue those traditional life ways? We need to, as a country, recognize those rights as embedded in human communities and also the lands that they steward.
We have to wrap it up there. This has been a fascinating conversation. I hope we get to talk again. Thanks so much for this philosophical conversation deep into the roots of our thinking and our legal system.
Thank you, Greg.
Thank you, Greg.
On today's Climate One, we've been talking about the legal rights of the natural world with lawyers Lindsey Schromen-Wawrin and Rebecca Tsosie and activist Carol Van Strum. To hear more Climate One conversations, subscribe to our podcast on Apple, Spotify, or wherever you get your pods. Talking about climate can be really difficult. Please help us get people talking more about it by giving us a rating or review. It really does help advance the climate conversation. Brad Marshland is our senior producer. Ariana Brocious is our producer and audio editor. The show is engineered by Arnav Gupta. Our team also includes Steve Fox, Kelly Pennington, and Tyler Reed. Dr. Gloria Duffy is CEO of the Commonwealth Club of California, the nonprofit and nonpartisan forum where our program originates. I'm Greg Dalton.